Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Kolkata ROC adjudication order for the violation of section 134 of the Companies Act in the matter of the Mr. Kejriwal Castings Limited. In this case, company name is the Kejriwal Casting Limited, having registered office in at Kolkata, West Bengal, as per the MCA record. Let's see the facts of the case. In this case, company and its MD has filed a suo motu application for adjudication of the offence under section 454 of the Companies Act for the contravention of section 134, which has been stated by them as the board report for the financial year ended 31st March 2019 could not be prepared within time due to non-availability of the financial data due to implementation and migration of the accounting data into ERP from Tally operating software and malfunctioning of newly adopted ERP accounting software. Further, board report for the financial year ended 31st March 2020 could not be ready due to delay in the accounting data due to the spread of the novel coronavirus and medical issues of the person looking after the same. Thus, the company has contravened the provision of section 134 of the Companies Act read with the relevant applicable rules. Let's see the legal provision as per the section 134 subsection 1 financial statement including consolidated financial statement if any shall be approved by the board of directors before they are signed on behalf of the board of director by the chairperson of the company and where is authorized by the board or by two directors out of which one shall be MD if any and the CEO or CFO and the company secretary of the company only by one director for submission to the auditor for his report thereof. As per subsection 3 of section 134, there shall be attached to the statement laid before a company in general meeting a report by its board of directors which shall include all necessary attachment as may be prescribed, and further subsection 8 of section 134 says that if any default in complying with the above provision, the company shall be liable to penalty of the 3 lakh rupees and every officer of the company whose default shall be liable to penalty of the 50,000 rupees. Where the office had issued notice for inquiry to the company and its MD for in default, to appear personally or through authorized representative before the adjudicating authority and notices were issued to submit their response if any 2 days prior to the date of the hearing. Due to preoccupation of the adjudicating authority, the matter has been adjourned and the authorized representative appeared on behalf of the company and its MD before the adjudicating authority on 8th April 2022. Authorized representative has submitted that the board report for the financial year ended 31st March 19 could not be prepared within time due to non-availability of the financial data due to implementation and migration of the accounting data into initially ERP from Tally operating software and malfunctioning of the newly adopted ERP accounting software and malfunctioning of the newly adopted ERP software consequent upon which the audit process got delayed. The company had also made an application for extension of the AGM for the financial year 31st March 2019, but the said application got rejected. The company then completed its audit and get the financial statement, including board report of the financial year ended 31st March 2019, signed, approved, and laid before the board of directors in the board meeting held on the 7th November 2019. The applicant also submitted that the board report for the financial year ended 31st March 2020 could not be ready and non-readiness of the board report is due to delay in the accounting data for financial statement due to the spread of the novel coronavirus and medical issue of the person managing the accounts and looking after the same. Fewer staff had tested positive for COVID, following which the management thought it fit to temporarily close office following COVID norms to prevent further spread among the other staff, and due to such difficulty, it led to delay in the preparation and closure of the books of account for the financial year ended 31st March 2020. The applicant further submit that the company has made its best possible efforts to get its accounts for the financial year ended 31st March 2020 compiled and audited by the statutory auditor of the company as the earliest possible and get the board report prepared. But delay occurred due to reason stated efforts, and as a result of the company could get its audit and board report completed and signed, approved and laid before the board of directors in its board meeting held on 28 May 2021. The applicant further stated therein their delay of details of the delay occur under section 129 of the Companies Act. For the 31st March 2019, there is the delay of the 48 days, and for the financial year 2000 ending 31st March 2020, there is delay of the 1 to 49 days. Thus, the company and its director, officer in default are liable to penalty as per the calculation submitted by the applicant. There is the on company there is 3 lakh, and on the managing director there is 50,000. There is total 3,50,000 for the financial year ended 2020 31st March 2019, and for the financial year ending 31st March 2020 there is 3,50,000. In order, having considered the facts and circumstances of the case and after taking into account the factors above, ROC imposed a penalty of the 6 lakh on the concerned company and 1 lakh on, each on the managing director, officer in default under section 134 subsection 8 of the Act for the failure to make compliance of the section 134 subsection 1 and section 134 subsection 3 of the Act for the financial year ended 31st March 2019 and 31st March 2020 respectively, and further that opinion that the penalty is commensurate with the aforesaid failure committed by the notices. The notices shall pay the said amount of the penalty individually for the company and its MD out of its own pocket by way of the e-payment available on the MCA website under pay miscellaneous fee category in the MCA fee and payment services within 90 days of receipt of this order. Further appeal, if any, preferred against this order may be filed with the, in writing with the regional director within 60 days from the date of the receipt of this order in form ADJ 1 setting for the grounds and appeal and shall accompanied by a certified copy of this order. Thank you so much for watching this order.